First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases scheduled for oral argument this afternoon. Our first case is Maoris versus State. Is the counsel ready to proceed?
Yes, Your Honor. Stephen Bernstein on behalf of the appellant.
You may approach.
Thank you, Your Honor.
Counsel will allocate 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, I'd like to reserve 5 minutes for rebuttal, Your Honor.
So noted, Madam Clerk. You may proceed, counsel.
Thank you. Your Honor, I'll begin with some of the facts that were stated in the briefs. While the appellee said that they agreed with the facts that we set out, they made some statements in their brief which were conclusionary and didn't really cite to something to establish them, and they're kind of consistent with what my argument goes to. They describe the appellant as acting when he later intended to rob the victim, he shot the victim. There was no testimony to support that particular statement. It may have been a conclusion that could be drawn, but that's not a fact in this case. In fact, the appellant in his statement indicated that at one time he characterized it as an accident, but he clearly stated that he never intended to rob the victim. And this case goes around the confusion that I believe the jury had in reviewing these facts because of their inconsistent verdicts. And that's my term, and I understand that's the issue, the big issue that we start with, because the jury found in in the trial it was count 2. In the information, it was count 3. Found him not guilty of intending or attempting to rob Mr. Green. And that's the key that causes a great deal of confusion, I believe, to this jury, to find him not guilty on that count.
Well, counsel, can I ask you on your first issue, if we agree with you that this is a true inconsistent verdict, what's the remedy?
Well, there's a two-part answer. The remedy is if you only consider that element or that issue alone, it would be acquittal, because there's no stepping down from that. It's an inconsistent verdict. It can't stand.
But didn't you argue that it should be JOA'd down to a second degree?
I did, and the reason I argue that, and that's the second part of the answer.
Because you and the state have switched positions now, apparently, on appeal. The state at trial said it would be an acquittal, and now are apparently arguing that we should JOA it down to second degree if it's inconsistent.
Well, and they not only switched positions on that, if the court will recall, at the trial, when we made argument on that motion to dismiss because of inconsistent verdicts, the state said, I acknowledge, listen, we were rushed. We went to trial on Monday the 15th. I filed a motion on the 12th, the Friday before, to suppress the statement of my client. We heard it on that day, and we tried this case on the Monday following that, and we went at a very fast pace. We tried this case in 2 days. I acknowledge that I did not have time, in my opinion, to consider all of it, and I missed the fact that the interlocking jury instruction should have been given. The state attorney argued, well, no, I thought of that. I clearly had it in mind, and I decided that this was not a case that it was appropriate for. On appeal now, the appellate counsel is saying, well, this is wrong for them to embrace the jury instructions as given and say that they're satisfied with them, but now to argue that there's an inconsistent verdict, so they should be barred from arguing that. I think that's disingenuous, jumping from their shift. At the same time, this was such a novel argument. When I first went in to argue this, I agreed, or I came up with, what's the remedy? Well, it's dismissal. Before this court, however, there's also an allegation. Our second issue is that the court should have granted a motion for judgment of acquittal. And you're still going to have to answer on that point.
Okay, well, let's say we agree with you just on the inconsistent verdict, but we think there's enough to have gone to the jury on your third issue.
I think that would be a real stretch, Your Honor, because the issue on the judgment of acquittal is that they didn't prove that there was an underlying felony to support the felony murder rule, and they only alleged felony murder, and they only charged.
I think you may be mixing the standards, though. The jury apparently found they didn't prove the attempted robbery, but whether it goes to the jury or not is just whether the state puts forth a prima facie case. So it's a lot lower standard than the jury ultimately determining beyond a reasonable doubt that he's not guilty.
Yes, sir, it is. But it's still the same issue. There was no evidence to establish that Mr. Green was being robbed. His wallet was still in his pocket, the evidence would show. The fact that he had, there was no indication and no evidence of a robbery at the time of the shooting. None. And I will go back to, I want to clarify one point that I think is very difficult to appreciate, and that is when there was the testimony of my client's uncle, Mr. Perry. He was out that evening, and he described having an interaction with the defendant, the appellant, and his associate, and he gave a description of where it was. And it was on an open area. It was a path. Now, there were two neighborhoods that were adjacent. One neighborhood had a path, which is where Mr. Green was found after he'd been shot, and it was well documented by the state in their presenting evidence by the evidence custodian. And the evidence custodian photographed it, and there is a fence, a wooden fence that goes along this area. That's where Mr. Green was found. There is no wooden fence where Mr. Perry gave his description of having come across these individuals. The importance there is the state argued consistently that they were still out trying to find a potential victim, unnamed, unidentified, to do a robbery to establish their felony murder argument where Mr. Green died. However, it's a completely different location. And the argument that I made was that when Mr. Perry came across these individuals, they were not in the area where the shooting happened. They were in the other neighborhood. And they came across Mr. Perry first. Mr. Perry, incidentally, said, I wasn't confronted by anybody with a firearm. They didn't know who each other was when they first came in the contact.
Can I ask you, I don't want to use all your time, but the jury was instructed on second-degree murder, right? And that so it would seem that if we JOA it down, that would be appropriate as opposed to acquittal altogether.
That's what I'm saying. There are two different arguments that the court should consider. And when you ask me what is the remedy if you find that there's inconsistent verdicts, I remind you that there's also the argument on the denial of the judgment of acquittal. If you find that the judgment of acquittal was not appropriate, not appropriately dismissed by the court and should have been granted, then we're left with a second-degree murder issue. Then the question would be, do we go to a retrial and say that's the most that can be happening, or do we say you find as a matter of law that it should have been second-degree murder?
Do you have any case authority in support of the argument that he should be acquitted if we find that it was subject to inconsistent verdicts in this case?
I do not. I don't have any case law that says that. However, when we researched it, we at the trial level researched it between the court, the state, and the defense. We found no authority saying exactly what would happen if it's granted. But the problem is that the motion is there's inconsistent verdicts and they can't stand. I would say...
if there are inconsistent verdicts and they can't stand, then shouldn't we send it back with instructions to the trial court to find him, judge him guilty of the lesser-included offense of second-degree murder, consistent with the case law?
That is one of the arguments, yes, sir. And that was my position when I appeared before the court, and I had to acknowledge that I didn't have a case that held that specifically when asked. I acknowledge to you that, yes, I think that is one potential outcome from this argument. And that would be one outcome that this court could rule. If you follow my arguments down the line.
It seems somewhat odd to me that the jury was instructed on second-degree murder, because that's not really a lesser of felony murder, or at least not a necessary lesser. Might be a permissive lesser.
Yes.
But I mean, to be guilty of second-degree murder, you don't have to be in the act of perpetrating some felony or even any crime.
Yes, sir. But we go back to what was the standard that was at issue at the time when that argument was made for judgment of acquittal, and I had to acknowledge, under the law, it was a permissible second-degree murder to be instructed on that if they found that. I see that I'm running short on my time, but I'm glad to entertain any other questions by the court.
Thank you, counsel.
Thank you.
Good afternoon.
You may approach the counsel.
Thank you. Good afternoon. My name is Darren Shippey. I represent the state of Florida in this matter. Make a quick couple of responses to opposing counsel's comments, the first of which, just to review my brief, you're going to find in the statement of facts as well as the statement of the case.
Counsel, do you concede that the jury reached legally inconsistent verdicts in this case?
I do. Like to be able to say no, but I do. It's clear under the evidence in this case that it was an inconsistent verdict. In any event, and just to kind of respond to Judge Bilbrey's, there's a Florida Rule of Criminal Procedure 3.620, I believe it is, that would have given the court the authority, had it felt it was the right thing to do, could have adjudged Mr. Maoris guilty of second-degree murder. They missed that as well in the motion for arrest of judgment hearing. This court has the authority under 924.34, make a determination if the evidence satisfies you that he's guilty of a lesser included offense, judge him guilty of that.
Does it matter that the second-degree murder is a permissive but not necessary lesser of felony murder?
It does not. It does not. You're reviewing the evidence in the case to determine whether or not that would be sufficient, that there's sufficient evidence to support that. And in this case, there clearly is. Opposing counsel wants to rely upon the beneficial things that his client said in his recorded interview and overlooks some of the reality of what was going on. The reality was that Mr. Maoris, by his own words, was out looking to do a lick. He was out looking to rob somebody that night. He started out with a target in mind. That person's name was Goggi, G-O-G-G-I. They were unsuccessful in that attempt. Mr. Goggi didn't come out of his residence. At some point, he encounters, it was not his uncle, it was his cousin, James Perry. And my memory of the evidence in the case is that a gun actually was drawn under the circumstances. And that may have actually been words that came out of Mr. Morris's mouth as well in his recorded statement, that he intended to rob that person, chose not to do so when he found out that it was his blood, it was his relative. So he didn't rob that person. Was given good advice by Mr. Perry at that time. You need to go home and you need to chill out. But Mr. Morris's response, by his own words, was, I've got to get money, got to do it for my family. And he was still mad. At some point, he encounters Mr. Green, who's the victim in this case. It's not a stretch to take the fact that he's mad. He intended to rob somebody, almost two people that night. A third person he encounters under what the record reflects is very dark circumstances. It's not light in that area. Encounters him, and by his own words, and I'm referring to page 368 of the trial transcript, so he was reaching in his pocket. This is Mr. Maoris speaking. So I thought he was going to grab a gun, so I pulled out my gun. I don't quite know who this is, and I cocked it back, and then I aimed it at him. He tried to grab the gun, so I jumped back and pulled the trigger, but I didn't mean to shoot him. So he admits encountering Mr. Green. There's some sort of an interaction, and we don't have to take what he says at face value. we're entitled to the reasonable inferences that go with that based upon what had been going on earlier in that evening, which was he was mad, he was looking for money, and he wanted to rob somebody. And that's what happened when he encountered Mr. Green. Perhaps Mr. Green resisted him. Perhaps Mr. Green said something. Perhaps Mr. Green reached in his pocket and scared him. But in any event, under those circumstances, by his own words, he pulls out a gun, he points it at him, and he shoots him. And we can add to that when you carry over to trial transcript page 369. And then when we shot, he ran, so I was like, he all right. He was running and holding his side and screaming and running. So I figure he went to somebody's house to call the ambulance. He runs away. He thwarted the attempt to rob him. And the shot that killed Mr. Green was a shot to his chest. Not his foot, not his leg, but his chest. It wasn't an accident. He can call it an accident, but that's not what happened, or that's not a reasonable inference based upon what happened previously in the case. So, under those circumstances, there's more than enough evidence when you add that to the other evidence that's uncontradicted to establish that there was an attempted robbery in this instance of Mr. Green. We get the benefit of reasonable inferences, and you'd have to find that no reasonable person could find the way that the judge did, which was to deny the motion for judgment of acquittal. Jumping back over to the felony murder, in this instance, the second-degree murder, and by the way, that would establish the elements of second-degree murder as well, which is the indifference to life, depraved mind, and the other things that are defined in the statute. And so I think
what is the sentencing range for a defendant convicted of second-degree murder?
I'm sorry, Your Honor?
What is the sentencing range for a defendant convicted of second-degree murder?
Are you asking if I have a case?
No. And what is the sentencing range in general under the statutes?
The evidence that he just described, that he was acting the way that he was acting, that he encounters the victim under these circumstances.
Well, I assume for the sake of argument, the defendant in this case had been convicted of second-degree murder.
Yes, I'm sorry.
What would have been the sentencing range for that defendant?
Got it. There you go. I'm sorry. It would have been a first-degree felony punishable up to life in prison.
Thank you.
Second-degree murder is a first-degree felony punishable up to life. The firearm and the jury's finding would have carried a 25-year min-man, which I think was in order at the original sentencing in any event. He wouldn't have had the restrictions, actually, that can apply under 921.1401 and 1402, or the statutes that applied in this instance, because he was 15 years at the time he did it. Those wouldn't have applied, interestingly enough, to a second-degree murder conviction. So the potential range would have been 25 years minimum mandatory, up to the possibility of a life in prison sentence.
And here on this, it was either 40 years or life, right?
Yes,
on the first
yes,
degree.
yeah.
So if we JOA it down, we got to send it back for resentencing.
You would send it back for resentencing based upon the jury's findings. Yes, yeah. So, like I say, what would happen is he'd face a 25-year minimum mandatory, up to the possibility of life in prison. Yes, that's what would happen under those circumstances.
No one, pardon me for interrupting.
Yes, Your Honor.
No one's talked yet about the motion to suppress. It does feel a little bit like a bit of chicanery where this juvenile says, I'd like to talk to my mom. The state knows that the mom has already turned against the son, sort of is acting on behalf of the state at that point in time. I'm not sure exactly why she did that, but she's now turned against her son. So they say, oh, sure, you can talk to your mom, knowing that she is working for them. So it has a feel to me of not being sort of a full and fair acceptance by the juvenile, because he didn't know his mom had turned against him and was working for the state. I suspect your response would be, well, even if that were true, it was enough to suppress it. What was disclosed in the conversation wasn't that bad. It was basically, he said it was an accident. So if you could just talk me through the first issue, was that a permissible police practice? And then secondly, if it wasn't, I assume if it wasn't, why is it harmless?
I didn't hear the second part. Let me answer the first part, and then
sure.
I'll come back to the second part. The first part is it was entirely proper. The judge went through a lengthy discussion on the record, and I've included that in my brief as to why it was proper. It's not improper for law enforcement to lie to a suspect. And if the result is they make incriminating statements, then the state gets to use those incriminating statements in trial. Whether you like that or whether it's good policy is a different day's discussion, perhaps with a different body. But what the law enforcement did was entirely proper. They did exactly what he asked. He says, "Can I talk to my mom?" Yes, you can. Now, I think what's a leap of faith is to assume that a mom is necessarily going to say, you need to shut up. Not every mom is going to say that, and I think it's disingenuous on the part of the defense to assume that because the potential co-defendant, I think somebody named Quintavious Jackson, his mom told him not to talk and he doesn't get charged. Well, that's not reflective of whether or not, pardon me?
But this mom was told, cutting the deal with, I guess, the state, was that you're going to get information out of your son.
They already had. She'd done her part. She was out of the picture, so to speak. She had warned the bug, had the conversation with him. That leads to the probable cause to arrest. He's taken into custody on the same day. He's taken down to the Alachua County Alachua County Police Department and talks with them. They didn't do anything. Law enforcement didn't. So there's no law enforcement action.
Well, but she's an agent of the law enforcement by then, right? I mean, she's been paid like what, $8,000.
She was paid $8,000, and that led to his arrest. And she was going to get the $8,000. I assume based upon that, because it seems the record is clear that she got paid the money. Led to the arrest. I don't think there was a conviction part of it that had anything to do with it.
And I certainly agree with you. There's plenty of cases that say law enforcement can lie to a defendant. But, I mean, there's some limit on that. Law enforcement couldn't send somebody in, send an officer in and say, hey, we got you an attorney. This guy's an attorney. Tell him everything you want to know. We're going to step out, go. I mean, there's some limit to the lie. And I think that's the concern here is obviously there's no privilege. There's no mother-son privilege. But there's some implication, at least, that this was going to be a private conversation.
Doesn't make any difference if it's private or not. What if she tells him the same thing if it's a private conversation? You need to go in there and own up to what you did. Wouldn't change anything. It's the conversation between a mom and a son, and the court should not assume that a mom is supposed to tell the son under those points, because we're all lawyers, and we know the lawyers tell everybody, don't talk. If you do, it's going to come back to haunt you. Well, that's not what we're talking about. She's not looking at it from that perspective. She's
working for the state, and it was recorded.
But she was not at the time. He asked to talk with her. He goes for 27 minutes denying any involvement. And then all of a sudden, out of the blue, on his own, he says, you know what? You let me talk to my mom and I'll talk to you. That's how it comes about. So I think you're stretching to assume that there was some state action in this instance, that the mom was hanging out ready to come in and swoop in and tell him to, confess your sins. That's not what happened. He asked to talk to mom. They did exactly what he asked. You talk to mom.
Okay, so you're saying there was no state contact with the mother, Canvas, prior to him talking to her?
No, they called her up to say, hey, he wants to talk to you. That's the way I understand the record, is that he asked to talk to her, they call her, they put her on the phone.
Okay, I mean, you may be totally right. I had a misconstruction then, because I thought that she had been contacted, or had been in contact with the state.
Well, she did, in the sense that, if you want to back it up, he's running his mouth to law enforcement a couple of days before that, may have been on the 26th, and the law enforcement officer knows who he is and knows who his mom is, gets in touch with mom and says, hey, will you come and talk to him and straighten him out? And she says, yeah, and by the way, I got something to tell you. He told me that he killed Green. So in follow-up to that, she wears I'll call it a bug, but it was really I think an app on the phone, and had a conversation with Mr. Maoris. That led to him being taken into custody. So there was contact. I don't want to think in any way, shape, or form that you don't think I was. But what I'm telling you, at the time of the interview, she was not a participant. She was out because he'd been taken into custody, if that makes sense.
Does the fact that he was a juvenile play any factor at all? I mean, here's the juvenile in custody being interrogated. He wants to talk to his mom. Okay. And it seems to me that, obviously, like Judge Bilber said, it's not a privileged relationship, but it's certainly one a juvenile would think was going to be certainly not recorded or not be turned over to the state. But obviously that was not the truth, because his mom had turned on him and I guess got a reward of some sort for turning him in. So doesn't the juvenile status, the 15-year-old mind, and sitting in this context matter at all, or maybe not?
No, doesn't affect the outcome.
It doesn't affect the voluntary.
Had he asked to speak with Mom, and they did not, I'm sorry.
It doesn't affect the voluntariness or the full understanding of his rights in that context?
No, they did exactly what they were supposed to do. They went through the whole process. I think the standard is set out in Rodriguez versus State, which is a Florida Supreme Court opinion. The court made the finding that he gave this statement voluntarily. The best evidence that it was voluntarily given is the fact that he denied having any knowledge or doing anything. I don't know what you're talking about. You got me in here talking about something I don't know. That was his response.
Did he make any incriminating statements in the telephone call with his mom?
Only to the sense that there was no dispute that he'd shot the victim. But his explanation to his mom was it was an accident. And really what Mom was saying was, well, you need to get out in front of this in case other people get arrested for it so that you're the first in line and they can look at you in a different light in that respect. So
he initially said, I didn't do it. Then when he told his mom, I did shoot, but it was an accident.
Mom knew that he did because he told her that before.
I'm focusing on what he said, not what Mom knew.
He said that in the conversation you're talking about, it was simply that he acknowledged, I think, that he had shot him.
Okay, so
and it was an accident.
That was a step toward incrimination. If he said,
Could
I did
be,
do
but
it,
as the defense did below and is trying to convince you now, I do the same thing in a closing argument. I'm spinning it and saying, well, he said it was an accident. So it wasn't as if he came in and said, you know what? I hunted this guy down, picked him out of a lineup, and shot him because that's what I wanted to do. He made me mad. None of that stuff. And the defense got the benefit of what he said, which was it was an accident. The jury didn't have to believe that, though. They can look at the bigger picture, and this court should be looking at the bigger picture in that regard. So in my mind, no issues whatsoever with respect to the motion to suppress in his statement. And I think the fallback argument would have been, in light of what he said, it would have been harmless error anyway. And I can see that I'm close to getting out of time, and there's not much more I could cover in 30 seconds, so I'll sit down at this point in time. Thank you.
Thank you, counsel.
Yes.
Let me start off with testimony of Mike Rodenwald, who was the lead investigator. There were no suspects until a Crime Stoppers tip, a bounty system with financial reward, here $8,000. And the person providing the tip was Candace Morris, the appellant's mother. That's the first time the law enforcement could connect Kainori Morris to the killing of Mr. Green. Before that time, he had no suspect. The other individual, Quantavious Jackson, when law enforcement reached out to contact him, was in a school. And not the mother, but the school contacted the mother and informed law enforcement that Mr. Jackson did not wish to speak, based on their calling the mother. Quantavious Jackson was never charged, and the same investigator said because we had no information that he had any connection to this case, unlike the situation with Candace Morris.
Well, I mean, maybe Mom's a better citizen than Mr. Jackson's
well,
mom.
The record also refutes that. The record shows that this young man had been in the care of DCF because both parents had been found unfit to take care of him. His father beat him. His mother was a drug addict.
And Judge Curtin took all that into effect, giving him 40 years.
Yes, sir, but if I could finish the point. He had been placed with Candace Morris 30 days before this event. 30 days. That's how long he'd been with his mother. His father had beat him. That's where he'd been removed from the last time. She had just gotten him. Within 30 days, she's telling law enforcement, for the price of $8,000, a reward that she's well acquainted with, she will set him up, get a statement. Her talking to law enforcement alone was not enough to arrest him, and law enforcement knew that. So then they made the arrangement for her to carry a recording device. It was her phone. They put an app on the phone. And then she had some really provocative, tell me what happened. And he said, well, I don't want to talk to you about this. But that's the conversation that generates him being arrested. She is well aware because she informs law enforcement where he is so he can be picked up. He then goes in to be questioned, and she's sitting at home with her phone, and when there are two things that I think are important. She answers immediately, and she tells him, you gotta get in front of this, you gotta talk. The mother he'd had for 30 days in this circumstance, and in the home where they had no food, and he felt compelled to go out and do a criminal act to get something in the refrigerator. These are my words, but that's the situation that this boy was in. Then, when law enforcement is there, they talk to him, and when the option comes up, well, I need to talk to my mother, they get her on the phone, they put the phone down on the table, and they say, we're going to leave the room so you can have some privacy to talk to your mother. And that's the conversation that goes on from there to where they come back in, and now he's going to confess to everything. So I think that your issue, Judge Maker, is this young man didn't appreciate the rights that he was giving up, that he had the right to remain silent, that he had the right to talk to an attorney before he went on. The only thing he knew is he wanted to talk to his mother, and he had nobody else.
But he had been Mirandized and was talking for almost 30 minutes before any of that happened.
And I would argue that he didn't have a good appreciation for that when law enforcement first told him about his rights, because they merely read him from a Miranda card. This is a young man who hadn't been schooled in a single school for any length. He didn't make 1 year in any consecutive school.
I mean, where's the constitutional violation? Did the police need, before the mother got on the phone with him, did they need to say, oh, by the way, your mom sold you out for $8,000, and anything you say to her, we're going to use against you too?
Well, I think when he first asked, when they first approach him, and he says, can my mother be here? Can I talk to my mother? That's before any statement. That's at the very beginning. And they say, your mother knows about this. That's it. I think not apprising this young man in that circumstance robs him of the help that the guidance he may need, and his lack of familiarity with what the Miranda warning means, that you have the right to talk to an attorney before you say anything. And then if you can't afford an attorney, one will be provided for you.
But counsel, the question is, what authority required law enforcement to inform appellant that his mother has supplied them with evidence against him?
I don't know that there's any that requires law enforcement to disclose that. I think under these circumstances, this young man did not knowingly, intelligently waive his rights. I'm not putting this at the feet of law enforcement, but I think that consistent with how they took advantage of the circumstance, they said, I mean, I find it offensive that they would say, this is going to be private. We're going to leave the room. Now, yes, they can lie to him. But under those circumstances, I don't feel, and I'm arguing to you, that that young man had no concept of the rights he was giving up. He'd been pushed down in every circumstance. His father, his mother, the system, now the law enforcement. I don't think he felt like he had any rights, and he gave those up under those situations. It's a far different circumstance from the young man who was in a school, and a school teacher said, stop right there, Mr. Law Enforcement. This young man isn't going to talk to you. Or contacted the mother and had, do you want your son talking to somebody? No. The differences are dramatic.
Thank you, counsel.
Thank you, Your Honor.
Our second case scheduled for oral argument this afternoon is Allstate Fire and Casualty Insurance Company versus the Maoris Castro. You may approach, counsel. Again, counsel, we will allocate 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor, if I could reserve 4 minutes.
How many?
4 minutes?
Thank you, counsel.
May it please the Court, Kevin Franz on behalf of Allstate Fire and Casualty Insurance Company. The trial court erred in this case in finding that the $25,000 payment by Allstate to the plaintiff was a confession of judgment and in entering a judgment in that amount against Allstate. The confession of judgment idea is a legal fiction that really has only been applied under a specific statute, which is 627-428. That usually applies where an insurance company denies coverage, forcing the insured to file suit. After the suit is filed, if there's a payment then, the Supreme Court in Waller has determined that is the functional equivalent of a confession of judgment. But the confession of judgment doctrine has never once been applied in a standard action under Section 627-727, where an insurer, like Allstate in this case, admits coverage and then settles vis-a-vis a cure.
You say it's never been applied. It was applied in Petrus and was affirmed by this court in an unwritten opinion. So it has been applied, right?
Well, it was applied at the circuit court, but the PCA has never.
Right, I understand that it has no precedential value. But you're limiting this confession of judgment to solely insurance. But, I mean, it's a much broader matter than that. Basically, anything where the damages are liquidated, if a party prior to the judgment coming in, but after suit is filed, says, here you go, here's the check, that's a confession of judgment, right?
Well, no, it really only, if the court looks at all of the cases since Waller.
I've seen it before on, promissory notes. I owe somebody $25,000. I didn't pay it back. They sue me. We litigate for a few months, and I say, here's 25. I mean, that's a confession of judgment, right?
Well, I don't know that might be a legal fiction applied in certain circumstances, but really primarily the case law where that sort of legal fiction applies, at least in the insurance context at minimum, is only under 627-428. A confession of judgment, it's an idea in common law that started in the early 1900s based on something called a cognovit, where you would consent to agree to a judgment. And the case in 1932, Carroll v. Gore applied that doctrine to foreign judgments. And then there was a statute, 55.05, that basically held those are null and void. So that's kind of where it starts. But really, it has only been applied at the vast, vast majority of cases, at least in the insurance context, to 627-428. And there's a reason for it. The Waller case looked at the public policy behind that statute, which is to discourage insurers from contesting valid claims and forcing an insured into suit.
Okay, let me give you a hypothetical. Years of litigation, UM claim, big UM claim, $1 million UM claim. Years of litigation, jury returns a verdict for $1 million for the insured. Before that verdict is reduced to judgment, the insurer says, here's your $1 million. Is that not a confession of judgment?
Well, it depends. If the case is brought based on a denial of coverage under 627-428, then it would be a confession of judgment. If there was a CRN at issue and the insurance company did not pay that timely, then you would have the case of Friedman, where it actually would not be allowed to be a confession of judgment. The plaintiff would be allowed to get damages. But in this case, what is critical here is that we admitted coverage. And under 627-727, if the insurance company admits coverage under subsection 8, specifically of that statute, the insured is not entitled to fees.
For bad faith, but why does that eliminate 768-79?
Well, we don't even get to that statute, because once there was a cure in this case, and a cure under TALIT means paying all of the UM benefits. That's what constitutes a cure. So in this case, the plaintiff said unsatisfactory settlement offer, and we cured that by timely paying the benefits. Once that occurred, the issue in the UM action, which could only be for $25,000, became moot. The trial court lost jurisdiction.
Counsel, didn't the insured file suit in this case because Allstate refused to give her as much as she thought she was entitled to?
And that is the critical difference here. One is a denial of coverage, which did not occur here. There's a big difference between a denial of coverage versus a disagreement over the amount of benefits.
There's certainly a difference under the insurance statute.
Correct.
But there's no difference under the demand for judgment statute. It doesn't matter why you had to sue your insurance company. If you ultimately recover a judgment 25% greater than what you offered to settle the case for, you win. It doesn't matter what you're suing for.
Well, correct, but to your earlier question, once there was a cure in this case, which effectively was a settlement, the jurisdiction of the trial court was lost other than to simply enter a dismissal with prejudice because the cause of action became moot. You don't even get to the offer of judgment statute in that instance because the claim became moot upon curing the
They don't even get cost?
No, the case is dismissed. There's no prevailing party.
What's your best authority for what you've just said?
Well, I would cite.
I mean, it seems like a lot of steps, and my point is, at least from my experience, when the company that I represent settles a case, they don't just send a check out and say, have a nice life. There's usually a bunch of paperwork, and there has to be a checks a box like, well, we're going to dismiss this with prejudice. I mean, there's a number of things typically when there's settlement. When you just throw a check at folks, I think it's a different situation.
Well, to your question, the authority, several cases. Apthorpe versus Denser from this court in 2015. The trial court lacked jurisdiction to issue a declaratory judgment due to the lack of justiciable controversy, and the case was remanded with dismissal for prejudice.
Yeah, but that wasn't a money judgment case, was it?
Well, it was dealt with a declaratory judgment. The question is, does the court lack jurisdiction to do anything else? And in this case, once the exact amount of money was paid that could possibly be recovered in this action, because remember, once we cured the CRN and there could be no bad faith action, then the maximum amount the plaintiff could receive in this action was the policy limits of $25,000.
Well, that's a great principle of law. If you want to settle, you just throw the money at them, and then the attorney's fees and costs and so forth to go away. I'm not sure that's the law.
Well, but it is under the statute. Again, if we were dealing with a denial of coverage, then Waller would apply. And if we forced the plaintiff to come litigate coverage, and then we said, okay, we agree with you, there's coverage, and we paid, then Waller applies. But it is.
Are the damages on the UM lawsuit different than the damages on the bad faith lawsuit?
Yes, absolutely. In fact, the statute, specifically under subsection 10, cites to the civil remedy statute, 624.155, and says only under a bad faith claim can you get these extra contractual damages, which includes fees. Here, there is no question that we can never get to a bad faith action because we timely cured in this case.
But aren't you asking us to add an exception to the offer of judgment, demand for judgment statute for that's not present for any other cause of action?
Not at all. Because again, basically, you'd be putting the cart before the horse to get to the offer of judgment statute. Once there was a cure and payment, that is designed to settle and resolve the case. That's what Talit says. And Talit says.
But counsel, wasn't the appellee forced to file suit based on Allstate's failure to pay her full amount of her claim?
That is not what's considered forced to file suit under the law. Only if there's a denial of coverage, complete denial, can you bring a suit under 627.42.
Well, I mean, it looks like there's two different standards there, and I absolutely agree with you. If this was a bad faith action, there's not, with the payment, there's not bad faith. But under the confession of judgment standard, there's got to be some effort first to try to get the money paid before you would get the confession of judgment. I think that's the distinction perhaps that Judge Lewis is trying to make, that they supposedly, or at least they would contend, that they had to sue because when they offered to settle pre-suit, it was denied, or maybe there wasn't even a response.
So I would rely on the case Florida Insurance Guaranteed versus Smothers, Florida 4th DCA 2011, which, quote, dispute as to the amount to be paid is not a denial of coverage. The legislature has sought fit to separate these two concepts. And in fact, under the statute, subsection 8, it says, unless there's a denial of coverage, you cannot get attorney's fees under 627428. That's from the legislature. That isn't my argument. I mean, that's not coming from me. The case law specifically reflects this. The Moore versus Allstate case, Florida Supreme Court 1990, an insured can only get attorney's fees under 627428 in a action where the insurer denies coverage. And that is what's critical to understand here, is that we're not dealing with a denial of coverage. If we were dealing with a denial of coverage, they would have brought suit under 627428. If we would have paid, they would have been entitled to attorney's fees under Wallard. But that is the critical difference here. And also,
But wasn't the insurance lawsuit and the insurance bad faith notice all related?
yeah, it's all related to this subject accident. The concept of settling through a cure and paying the policy limits on this claim are not mutually exclusive. They all, in fact, occurred. But once that occurred, it left no further judicial controversy in this action because the plaintiff recovered everything that they were entitled to recover under law, which was the policy limits. So we would request that this court reverse and remand for dismissal with prejudice.
Before we sit down, counsel, had Allstate not defended the insured's lawsuit or accepted her settlement demand, the insured wouldn't have had to file her bad faith notice, would she?
Your Honor, could you repeat that? I apologize.
Had Allstate not defended the insured's lawsuit or accepted her settlement demand, the insured wouldn't have had to file her bad faith notice.
I can't say if that's accurate or not. All I can say is that Allstate was not under an obligation to simply accept a proposal for settlement. And the reason being is because in this case, there was about $60,000 in collateral set-offs, being PIP and being the bodily injury payments that were made by the tortfeasor. So you start at a point where we're only obligated to pay $25,000. Then you deduct that $60,000 because that's the amount that we're entitled to is for a set-off. So simply filing a proposal for settlement for $18,500, it might sound good, but doesn't take into consideration other reasons why you might reject that. And that's what occurred in this case.
Judge Bibby referenced the prior lawsuit, which was a similar case to this case, where Allstate was involved as well. Even though this court entered a PCA in that case, which has no presidential value, can you distinguish this case from that case?
There are additional arguments that we made regarding a settlement in this case, regarding a settlement being one of the factors that would provide for reversal, as opposed to simply just curing the CRN. The amounts, the circumstances regarding the CRN were possibly different in both cases. Most importantly, we have really no idea whatsoever why the PCA was entered, but it shouldn't be used against us in this case because every case deserves, you should not have extra records brought into this case, and that would include Petrel. So the court really should not consider that because we have no idea why it was PCA'd and because a PCA carries no weight with it. So we would ask that this court look at this case with de novo, with eyes anew.
Thank you, counsel.
Thank you.
You may approach and you may proceed, counsel.
Thank you, Your Honor. May it please the Court, my name is Bailey Howard, and I represent the appellee in these cases, I should say, Ms. Maoris, Jeanette Columba Castro. And, Your Honors, I'd like to begin by setting the scene a little and doing some myth-busting, discussing what this Court has before it today and what this Court does not have before it today. This Court does not have before it a claim for attorney's fees under Section 627.428. The parties agree that that statute does not apply here. So questions of whether Ms. Columba Castro was forced to sue by Allstate's conduct under the applicable law are
Is the
not
purpose behind both statutes the same or different?
both statutes being 627.428 and 768.79, Your Honor?
That is correct.
I think they're related, they're not identical in their purpose. 627.428 is supposed to, according to the case law interpreting it, is supposed to incentivize insurers to pay meritorious claims. 768.79 is a little broader and therefore a little bit more nuanced in its application. It's designed to promote settlement by a sort of carrot and stick method of an offer of judgment that one party, it sort of takes into account the parties' respective risk appetites, but in both statutes we have the word judgment. And in 627.428, it's judgment or decree, and that's what the confession of judgment doctrine that some of the cases refer to is talking about. It's that a confession of judgment can satisfy the phrase judgment or decree in 627.428. And in 768.79, we have the phrase judgment obtained. And part of our argument here is that because a payment in mid-litigation of a disputed sum is tantamount to a confession of judgment in favor of the receiving party, or in the context of insurance cases, in favor of the insured, as the Supreme Court of Florida has held many times, going back from Woolard in 1983 up until I believe the most recent case cited in our brief from the Supreme Court is a 2016 case, Johnson versus Omega Insurance Company. That principle has great validity. But the only question then is how you get from there to an attorney's fee award. And that is what the confession of judgment doctrine in the 627.428 context means. But confessions of judgment are not a legal fiction. It's difficult to classify exactly what they are, but they're sort of a quasi-pleading affirmative defense that waives the defense, if you will, or something like waiver, that is a method of pleading something that hasn't been codified into a rule or statute. They are, as my friend admits, a common law principle, and that means they apply anywhere a statute or a court of last resort has not excluded them from applying. And Allstate here points to not a single word in any statute, except for 55.05, that restricts the confession of judgment doctrine from applying. And my friend didn't quite delve into the details of 55.05. It doesn't apply here, but it didn't void Carroll versus Gore. What 55.05 says is that you can't confess judgment by power of attorney when that power of attorney was created before the suit in question was filed, and then do it by defaulting rather than by affirmatively confessing the judgment, either by a cognovit, as my friend alluded to, or by performance, which is what happened in this case. Paying the $25,000. I'm sorry, Judge.
Why isn't this just a straightforward settlement? I mean, they sent you money. I don't know what the cover letter said or if there's anything on the check that said this is in settlement of whatever. I don't know what you did in response to it. Maybe you can walk me through all this. But you get a check in the mail. It sounds like it just went to the bank, and next thing we know, it's a confession of judgment. Why isn't it just a settlement and not something that needs to be reduced to judgment?
Well, Your Honor, as Your Honor alluded to, it is a little bit of a process, so I'll walk you through it. So there were no settlement negotiations of any kind. There was the CRN, which per statute is not it says that its sole purpose, it has to say on the CRN form that its sole purpose is to perfect the later bad faith claim and to afford the insurer an opportunity to cure. So our position is that no reasonable person would interpret that as a settlement offer. There was no other thing that could be construed as a settlement negotiation. Then when
was there a settlement agreement?
No, Your Honor, there was not.
Did Allstate place any conditions on acceptance of the payment?
No, Your Honor. In fact, they explicitly did the opposite in an email that was sent from Allstate's counsel, Mr. Kennedy, to Ms. Columba Castro's counsel, Mr. Moore, around the time that the check was cashed. And so that the check itself says that it's in payment for, and I can't find the exact quote in my memory, Your Honor, I'm sorry, but the check says it's in payment for the UM benefits. And the reason for the payment is primary coverage, Florida date of loss 12/6/2017, I believe. And there was a sheet that accompanied the check, which this court should only really look to if the check were at all ambiguous. And the check was not ambiguous. It says this is what it's for. And when we're talking about what is the purpose of a negotiable instrument, one looks to the negotiable instrument. But to look to the check information sheet that accompanied it, the sheet did say that the reason for payment was nego settle. But that is the only fact in the record that suggests there was any kind of settlement negotiation that took place. And there's no evidence in the record to discuss how Allstate's system generated that statement or why. There's also nothing in the record, even if we assume that there was some kind of settlement negotiation that the record does not reflect, the record does not contain competent substantial evidence from which to determine what the terms of any supposed settlement agreement would have been. As Your Honor, Judge Makar alluded to earlier in this oral argument, it's not just, here's your check, have a nice life. We have to determine, are we going to enter a judgment? Who is that judgment going to be in favor of? And what will happen to the pending claim for attorney's fees? And none of those questions have been answered here, which means not only are there no enforceable terms of a settlement agreement that can be discerned from the record, but neither party gave sufficient consideration to support any purported settlement agreement, because all Allstate did was something it was required to do anyway under the policy, which means it's also not in accord and satisfaction, and that Ms. Columba-Castro is not a stop to deny a settlement agreement because the only benefits she accepted were the benefits of her policy, not some supposed settlement agreement that the record does not reflect.
I'm sorry, I don't know what the record says on this, but did you all take any steps to say to the trial judge, oh, we're not going to cash the check, we're going to have a hearing, we want this to be a confession of judgment, we want a judgment from the court? I don't remember exactly how it played out procedurally, so maybe you could bring me up to speed on that.
Certainly, Your Honor. The way it played out was when Ms. Columba-Castro's trial counsel received the check in the mail, they emailed, I believe they emailed, yes, and I believe the emails are in the record. I believe they emailed Allstate's counsel and said, we've got this check. Are there any conditions that are attached to this check? And Allstate responded by sending back a standard waiver, but was clear that that waiver was not a contingency for the settlement. That they said, I'm not trying to add any conditions or renegotiate anything, were their exact words, I believe. And I apologize that I don't have the record site at my fingertips for you, Your Honor, but I promise it's there. And then there were sort of dueling motions at that point. Ms. Columba-Castro moved for entry of a confessed judgment pursuant to the cases that are cited in our brief, and Allstate moved for entry of a judgment of dismissal, arguing, pursuant to the cases cited in their brief, that the case was now moot.
Are you aware of any material difference between this and the Petrus case?
Your Honor, I am not.
You had asked that we take judicial notice of Petrus, and that was whoever saw that before deferred it to this panel. Is there any particular reason why we should or shouldn't take judicial notice of Petrus?
Yes, Your Honor. This Court should take judicial notice of Petrus, and let me be absolutely clear, not for the basis of any precedential value that Petrus has, because it has none. And I should be very, very clear about that. But the reason this Court should take notice of Petrus is that this is not an isolated incident. This is a lacuna in the case law where a party pays disputed benefits during a case that is litigating whether it should pay those benefits. And the question is, does that confess judgment on the claim for those benefits? And Ms. Columba-Castro's position is that that is not an open question in the case law. That is well settled by cases from the Supreme Court of Florida. What is a question is, does a CRN affect that? And what is its effect on entitlement to attorney's fees outside the context of Section 627.428? Because that's another question that's bookended by well-established, well-recognized case law. And so the point of looking to Petrus is not for precedential value. It's not to guide this Court's decision on the merits in one direction or another. The reason for looking to Petrus is so that this Court appreciates that there is more than just this case that has dealt with this question before, to avoid the possibility of being locked in by tunnel vision, as one of the cases states, but not to bind this Court's hands in any way. The PCA, of course, has no precedential value, so the prior panel rule from Little versus State does not apply here.
Doesn't that end the discussion, though, since PCA has no precedential value?
I'm sorry, Your Honor, could you repeat the first
Doesn't that end the
sentence?
discussion, though, since the PCA has no precedential value?
Effectively, Your Honor, yes, but I don't see that it also means that this court must blind itself to the historical facts of the fact that there is more than just this one case that has raised this issue, that this is something that's important, that it is capable of repetition but evading review if courts just PCA or deal summarily with cases on this basis, or if they're not appealed. Because
But the PCS side, are you aware of any case authority applying the confession of judgment doctrine when an insurer cures a potential bad faith action by selling a UM claim off for purposes of 768.79?
No, Your Honor, I'm not. If I had those cases, I would have cited them for you.
Thank you, counsel.
Yes, Your Honor.
So you want a written affirmance?
Well, Your Honor, I want a lot of things. But, of course, I recognize that this court has...
But you take a PCA. Okay.
Your Honor, I leave that to this court's sound discretion. There's a reason Your Honors wear the robes and I do not. And so, Your Honors, unless this court has any further questions on which I can assist, I will rest on my briefs and leave the remainder of my time to this court.
Thank you, counsel.
Thank you, Your Honors.
Counsel said the confession of judgment is not a legal fiction, but Tampa versus State Farm from the 5th ECA says, in referring to 627-428, quote, by using the legal fiction of a confession of judgment, our Supreme Court has extended the statute's application to cases in which the insurer settles or pays a disputed claim before rendition of a judgment. What Waller did was apply this common law doctrine to statutory interpretation. It applied a very rarely used doctrine called the absurdity doctrine to take the common law legal fiction of a confession of judgment to section 627-428. What plaintiff is asking this court to do is to use the absurdity doctrine to take that legal fiction and apply it to 627.
Well, aren't they just asking us to read 76879 by its plain text, that nothing there exempts a UM claim? The bad faith statute is different, and sometimes you can have multiple bases for recovery of fees.
Well, I think, to your question, there is a significant difference between the offer of judgment statute and 627-428. The purpose behind 627-428 is to discourage insurers from contesting valid claims. The purpose behind 678.79 is punitive in nature. So one is remedial, one is punitive. So there's different circumstances for why one would apply and why one would not. But in this case, upon the settlement and cure, that fully resolved the case. And to Judge Makar's point, was this a simple settlement? Yes. They demanded policy limits. We sent them a check. They cashed the check. There's a plethora of case law, including Stevenson, which says if you cash a check, you're accepting the settlement benefits. And was there any question of whether this was a settlement? We actually have the evidence from plaintiff's counsel's affidavit that says, well, when they sent me the check, I said, and they sent me a release, is the release a condition to the settlement? Our response, no, it is not a condition to the settlement. And the settlement was cashed. The settlement check was cashed. That constitutes a settlement. And the question of all the procedures of what happens after a settlement, I would rely on State Farm versus Nichols, which says that a dismissal is not a condition of a settlement, but is a legally inconsequential means of effecting it. So once there was a settlement, all that was left to do in this case was dismiss the action with prejudice. And, Your Honors, for all of these reasons, we would request that the court reverse and remand for dismissal with prejudice, unless the court has any other questions.
And thank you, counsel.
Thank you.
And thank both of you for your respective arguments this afternoon. This concludes our session for this afternoon. We stand in recess.
All rise.